appellant's case, of course, would put the respondent in breach even before the security is provided. And that is an extreme result required neither by the wording of Clause C nor the commercial coherence of the CJA. And with that, my lords, I'm going to turn to the appeal, and I'm conscious I'm accelerating a bit, and if I go too fast, please slow me down. There are 4 issues on the appeal, effectively, 4 questions. Did the appellant provide security? If it did, was the respondent bound by it? If it didn't, does the true construction of Clause C mean the respondent was bound to accept an offer to provide it? And if not, should a term be implied requiring the respondent to accept an offer of reasonably acceptable security? Now, of course, the answer of my submission to all those questions is no. And for the purpose of my submissions, I'm going to regroup them into 3. The question whether the appellant provided security. Secondly, the express term issue, or put another way, the true construction of Clause C. And thirdly, the implied term issue. Before I come to the first of those, may I make the overarching point that even today, even now, the term that my learned friend must say arises on the true construction or by way of implication is being reformulated. And in fact, I still don't really know what it is, and I don't really understand how he says it is breached. And that speaks against both limbs of his argument. And I will leave that there. But the elusive character of this term, both as regards its content and the way in which it is breached, will not have escaped your lordship. So, did the appellant provide security? Now, I accept that it is possible in principle for the securing party to perform its Clause C obligation by simply providing security in reasonably satisfactory form. I'm leaving to one side the form issue raised by my respondent's notice, and I'm assuming for these purposes that form does encompass every feature of the security, including the party providing it. But that party cannot provide security by doing something that falls short of providing security. At the very least, it must tender the security. And could I ask your lordships on that to turn up the brief extract from Chitty, which is, I hope, at the very end of the authorities bundle at page 466. Could I ask your lordship simply to read the passage in 24082, which is sidelined? So what did the appellant actually do? Now, for the answer to that question, could you turn in the supplemental bundle to page 230?
230?
230, my lord, yes. So just to get the sequence of events into your lordship's mind, the vessel was arrested. The Britannia then sent a draft LOU. That was rejected, and questions were raised about the Iranian nexus, which was being advised for the first time. The response to that was this email that we're looking at on page 230. And on the first page of the email, the requested details regarding the Iranian nexus are set out. And then over the page, the top two lines, we are attaching a revised wording for the draft LOU that we are prepared to give on behalf of our members in respect to the claims of your members in relation to the collision incident described. And then dropping down to just above the, we look forward to hearing from you, those three lines above that, can you please review the attached wording and let us know as soon as possible whether you and your members are prepared to accept security on these terms in principle, i.e. only subject to consulting PIG. Now the LOU itself is over the page again. And if you could turn it up. Now, the detail here doesn't matter. But what does matter is you can see at a glance that this is a draft and not the perfected instrument. To take just 2 points, it's covered with track changes, showing clearly that this is a draft. And secondly, it is incomplete in that, firstly, a space for letterhead is indicated but not filled. A space for signature is indicated but empty, and a space for a date is there but incomplete. And yet, my lords, my learned friend's primary case is that my client is bound by and could sue on this document. That is paragraph 51 at page 106 of the bundle of his skeleton. The core of that case is at paragraph 52 on page 107 of his skeleton. And could you please turn that up? That's not addressed in my skeleton because it is completely new. I should say no complaint about that, but that's why I'm going to.
Which page?
Page 107
Yes.
of the core bundle. So the first point he makes, and that I cavil with, is his characterization of the provision of the draft LOU as a matter of courtesy. That is not how it was expressed in the covering email, and the evidence doesn't support that as a matter of practice. Indeed, there's no evidence of that as a matter of practice. As for his suggestion that the law doesn't require one to perform a step rendered futile by the other's breach, a number of points. First, at the time of this supposed performance, which is when this email is sent, my client was self-evidently not yet in breach, if it ever was. Secondly, if the correct analysis is that no acceptance is required, as submitted in this paragraph, then logically rejection is not a breach anyway. Thirdly, no authority is advanced for this contention, and if it has any validity, it can only, in my submission, be by reference to the principle of tender, which, as the extract from Chitty makes clear, requires first an unconditional offer to perform the promise, and secondly, in circumstances in which that party cannot complete its obligations without the other's concurrence. So performance would require a tendering of the perfected security. Nothing my client did prevented that, but it wasn't done. And so this part of the appeal simply cannot work. You can look at it this way. If, having rejected this draft LOU, my client had tried to claim on it, it would have been met with an insurmountable defence that it had never agreed to its terms, and no perfected LOU, indeed it had rejected its terms, and no perfected LOU had ever been provided.
If we're looking at two elements for the purpose of tender, one being an unconditional offer to perform, and the other being that you need the cooperation of the other party, why doesn't the draft at paragraph page 232 satisfy that? It's an unconditional offer to provide an LOU, obviously on the Britannia letterhead, it says so, and signed by an authorised person on the date on which it will be signed. And as to the second requirement, it may be a technicality, but they need you to tell them the place of incorporation or domicile of the standards member.
I don't take a particular point on that omission, my lord, but what is being presented here is an offer of performance that is capable of acceptance, that is asking for acceptance. It is not, in the sense of tender, in that sense, unconditional.
But I mean, there's no doubt, is there, that if you said yes, thank you very much, the Britannia would have issued a document saying all the right things, and, signed and on their letterhead and all the rest of it.
That's right. But where something is an offer, where something looks and feels like an offer, and it is rejected, then to come back afterwards and say, well, you may have rejected that offer, and we may have gone on negotiating as we did for some time, but I'm now going to rely on that offer as a tender. That is stretching the whole concept of tender well beyond its established remit, its established bounds, in my respectful submission. That was indeed what I was next going to say. It would be both an unwarranted and an unnecessary extension of the principle of tender to hold that a draft unsigned document, obviously being offered and not tendered, and which obviously anticipated both completion and signature, was binding on both parties, notwithstanding rejection by the offeree. Now, as for the parenthesis in my learned friend's paragraph 51, which is the second unnumbered paragraph of it, he takes a point about the pleaded case. The pleaded case was directed to paragraph 3 of the particulars of claim, which contended that each party was required to accept. We better turn it up, actually, because otherwise it's not going to make sense. Could you turn, please, in the supplemental bundle to page 204? Actually, we'll start on 203, my lords, I apologise. So in the amended defence, which is paragraph 3 is the paragraph in which the subparagraph relied on by my learned friend appears. Paragraph 3 is responding to paragraph 3 of the particulars of claim and denying it, and the subparagraph is advanced as a support to that denial. And paragraph 3 of the particulars of claim is on page 196. and it is advancing a case that on the true construction of Clause C, each party was required to accept security objectively reasonably satisfactory or would not act unreasonably by rejecting such security. And so it's addressing a different case to the one that I was advancing in my skeleton, which is my learned friend's new point that acceptance is redundant. Now, my learned friend also quotes then from my expert in that extra paragraph, but that quotation supports negotiation, not the reverse. As for the reference to the Sanctions Committee, that's irrelevant to this question. As for his common use point, there is no evidence that this sanctions clause was ever used before it was offered to my client. In fact, the evidence is clear it hadn't been, because it was an adaptation made by the Britannia Club to the wording it had offered last time around. And you can pick that up, firstly, in the chronology at page 161. And if unusually, I could ask you to look at that, please. 161 at 29. This is an email. We have to go back a page to see when the email was sent, the 6th of September. Britannia to the Standard Club, with discussion of the sanctions clause, and then the very last sentence in that box, I am working on a wording which I hope can achieve this. And then if we go back to the email in the supplemental bundle at 231, in numbered paragraph 1 begins, we do not agree with your various comments regarding the sanctions clause we initially proposed. Nevertheless, we have made amendments to the clause, and the new version seeks to achieve a balance between the wording we put forward and your wording. And all the other examples relied on, all the other examples of LOUs with this clause in it, relied on by the appellant, their later dates, some of them much later. So at the time it was offered, there was no common use, even if that could make unreasonable security reasonable. And even more to the point, none of this goes to whether there was an effective tender. So in conclusion on this first issue, then, the appellant did not, I submit, on any view perform, and in fact has never performed its obligation under Clause C by providing security. That brings me to the express term. And the questions on the express term are whether on its true construction, Clause C obliged the respondent to accept either one, security provided by the appellant, if, contrary to the submissions I've just made, security was provided by the appellant, or two, an offer of security. The first point is that, as my learned friend submits in his paragraph 53, the clause expressly requires the provision of security and not merely an offer of it. Now, as to that, if I'm right that what happened was an offer and not a provision, an offer cannot become a provision just because the clause requires a provision. And consistently with that, the market practice is first to seek to agree the terms of the security and then to provide it. And that practice avoids disagreements, such as whether security in X or Y terms would be reasonably satisfactory. and it would be undermined by a decision that what looks very much like an offer as to the terms of performance is to be treated as the performance itself, and with respect it should not be. And this approach fits, in my submission, with the structure of the ASG 1-2 forms that the judge identified at paragraph 94 of the judgment, which is that it's only on the provision of security in ASG 1 form that the right to arrest is lost. Now, my lords, against that background, an offer to provide security in those terms would not be understood to be the provision of it. Pausing there, if the appellant's argument has any force, well, let me put that less tendentiously. The force of my learned friend's argument is that there should be, and he would say therefore is, and that's a non sequitur, but he says there should be some reciprocity in clause C. So the obligation to provide security is matched by an obligation to accept it. Now, even if that were right, I do apologize, I've just lost my place. Even if that were right, the obligation to accept could only be triggered by the performance of the obligation to provide. The construction that the appellant seeks, or at least one of the constructions he seeks, is that the respondent's obligation is triggered before the appellant's has been performed. And that makes no sense, certainly if the triggering of the respondent's obligation means that from that moment on, the initiation or maintenance of any arrest is a breach of contract standing in damages. Thirdly, and even more pressingly, the force of the appellant's argument really leads only to the conclusion that reciprocity might be something the parties might have wanted to agree. It doesn't lead to the conclusion that that is what they did agree. And the fundamental difficulty with the appellant's case, so far as concerns any express term, is that the words to support it are just not there. My learned friend cited and then didn't, well, he cites in paragraph 45 and quotes from my Lord Justice Lewison's book at paragraph 2.43. Perhaps, my Lords, we might just turn that up. It's page 104 of the core bundle. The bottom of the page.
Give me the page number again.
104, my Lord.
104.
When interpreting a contract, the court is concerned to find the intention of the party or the parties, and it does this by identifying the meaning of the relevant words. In light of, 1, the natural and ordinary meaning of those words. Pausing there. And that is counterproductive to the appellant's case because there are no relevant words to construe. Now, he has 3 answers to that. His first, which he hasn't really pressed on you, is divani. And then, unless your lordships would be assisted by me assisting with divani, I'm going to leave divani at paragraph 26 of my skeleton, where I explain why it really doesn't help. This is not a typical case of the supermarket checkout, where the context makes it entirely clear what the parties are talking about. His second point is to look at what he calls the relevant matters in paragraph 49 of his skeleton. If, my lords, you could turn that up or turn over to that, it's on page 105. I've dealt with the first 2 of those, and I also address it in paragraph 27, 1 to 3 of my skeleton, pages 53 to 54 of the bundle. As for the third, which is Claimant, I address that in paragraphs 14 to 15 of my skeleton, pages 46 to 47. But in short, the case is not authority, as my learned friend was effectively compelled to accept, for the proposition that seeking additional security is breach of the jurisdiction clause. That proposition is a non-starter. Claimant was dealing, and dealing only, with an attempt to circumvent an arbitration clause by insisting on security that submitted the underlying dispute to the jurisdiction of the Senegal courts. And that is so far removed from our case as to not make it a worthwhile analogue at all. My learned friend's third answer is to focus on the words provide and reasonably satisfactory. Now, I've dealt with provide, and as for reasonably satisfactory, this is paragraphs 54 to 56 of his skeleton at pages 107 and 8. But the points he makes there go nowhere. The point of these words, reasonably satisfactory, is that that is the quality that the security to be provided must have. Don't shed any meaning, light, I should say, on the meaning of the word provide. And my approach doesn't make, as he suggests, those words odious. That's not our case. Our case is that security that isn't in reasonably satisfactory form can't comply with the clause. That's the framework that is set by the clause. The appellant's case appears to be that reasonably satisfactory not only colours the offeror's obligation, but is to be read as saying, and shall accordingly be accepted by the offeree. That's the construction he's trying to put on it. But that involves a rewriting of the words, or if not a rewriting, a quite radical reinterpretation to mean two rather different things at the same time. The short point is that the clause requires A to provide something, and there are no words requiring B to accept it. And your lordships should therefore, in my submission, reject the case founded on express term. That brings me to implied term. My learned friend submits in paragraph 65, page 109.
Just go to pause a moment. If security had been provided by a payment into court, would there be anything for the counterparty to accept?
No. And indeed,
So if secure, so depending on the form of security, it might or might not require something for the counterparty to do. Is that right?
Well, my lord, yes. In that, if the security is to take documentary form, then generally, not inevitably, theoretically, but generally, some discussion between the parties would be needed in order to get the names of the parties right, the amount of the security right. And you're always, even when you have security which is on bare ASG 1 terms, you're still going to have a discussion as to what should go into it. So to that extent, yes. But even if there were to be a payment into court, I suppose there might still be an anterior discussion about the amount to be paid in. But none of that theoretically is necessary. If the amount of the claim plus cost plus interest is clear, or a demand has simply been made, we want security of X, then security in any of these forms, barring probably escrow, could be made without further discussion. theoretically. It doesn't happen in practice, but theoretically.
No, but if we're trying to find out what the contract means,
Of course.
If you're right, the clause C is limited to the otherwise arresting party, your client, being offered security by the other party, isn't it? In other words, you couldn't, in fact, have just written it, each party will offer security in respect of the other's claim in a form reasonably satisfactory to the other. In fact, you wouldn't have needed the rest of it, because if you're right, you're not obliged to accept anything at all, whether reasonable or otherwise. So all it would have actually had to say was each party will offer security in respect of the other's claim.
Well, it could say that, but that would be...
Isn't that the effect of your submission?
It's not,
What it
my lord,
means.
no, because the effect of my submission is that if the effect of my construction of the clause is that if the providing party complies with, or if each party, because it's a reciprocal thing and we mustn't lose sight of that, if the securing party provides security which the clause requires, then that may well have a number of real-world and legal consequences. In particular, the commercial reality is that in at least 99 cases out of 100, that will be that, and the now secured party will say, thank you very much, I'll now lift my arrest, or I won't pursue an arrest, or whatever it will be. But if they don't do that and there is an arrest or the maintenance of arrest, well then we're into applications to set aside potentially the anti-suit injunction we've been discussing, potentially claims for wrongful arrest. It's not something which happens in a legal void. It's not something that I'm drifting into implication, but it's not something that requires the implication of a contractual term to give it an edge. So the edge is there.
Does it mean, to pick up my words on that point, that it effectively just means that each party will provide security in a form which doesn't require the other party to do anything?
What it... It's difficult to take oneself away from the facts of the case. One thing I haven't given thought to, and I apologise, is trying to come up with an example of a form of security which might be reasonable while not being reasonably satisfactory to the recipient. But the clause in effect requires provision of the sort of security that would be approved by the English court. In a shorthand way, that's what it does, because that is what the court would order, and the court this court, not every court, but the Admiralty Court in London, accepts security in the form of that LOUs from P&I clubs and so on are fine. There are jurisdictions that say no, there has to be a payment into court, and so on. We're relatively flexible on that point. So that effectively is what has been done, just in a rather neater way.
And presumably it would be possible, and may not happen ever, for an LOU to be provided without the first few lines saying in consideration of your releasing the ship, made by deed. So it wouldn't need any consideration, it would just be enforceable.
Yeah. Certainly. I mean, yes, I mean, as a theoretical example to test the boundaries of the clause, yes. So, my lords, unless I can help further on the express term, the implied term, my learned friend submits, if we get this far, that without the implied term for which he contends, and I repeat that I am still not entirely clear as to what the terms of that term are, clause C is pointless. That's paragraph 65 of his discussion. But as I've already submitted, the clause is not so much pointless as toothless. a toothless obligation to provide security balanced by the lack of an obligation to accept it. Clause C provides the quality that the security to be provided must have, but that doesn't affect or add much to the reality that without Clause C, the party to be secured would have to arrest or credibly threaten arrest to obtain security if the other party failed to provide it on demand, which of course also exists with Clause C in place, and also doesn't affect the fact that in most jurisdictions an arrest would only ever produce security that was reasonable in form and amount, as it would have to be sanctioned by a court in the absence of agreement. So, as I've already submitted, Clause C adds little beyond an expectation of engagement with a view to acceptable security being agreed and provided. And in many cases, most, that is all that's needed. But in the edge cases, I don't know if edge cases is a familiar term, I gather it's used in computer programming. The outlier cases like this, where parties have been pushed, the situation is really not much affected by the existence of Clause C. Now, I want to address paragraph 66 of my learned friend's skeleton. It's on page 110. This paragraph, with respect, looks at the problem uniquely from a distorted, from the perspective of a distorted version of the facts of this case. It's distorted because on the facts, no one went in search of better security in a foreign jurisdiction. As I've already made clear, the arrest in South Africa was made at a time when, despite chasers, no security was on offer. And that's the judgment, paragraphs 24 to 26. Secondly, the security that was obtained in South Africa was not better than reasonably satisfactory, as my learned friend would have it, both in argument this morning and in paragraph 8
you're
of his skeleton.
hitting the right target, surely. I mean, this paragraph 66 doesn't say that's what you did. It's being relied on as an argument for implying the term.
Well, it is. And one of the arguments is that dashing off to foreign jurisdictions to obtain better security is something that the clause, the term he wants, would supposedly prevent. But that is still he is playing on the facts of this case and a distorted version of them. The security sought and obtained in South Africa wasn't better than reasonable. It doesn't have a sanctions clause, but as the judge pointed out, that may not make any difference. It's subject to sustained and ongoing challenge. One might add as an aside that challenge and the costs involved are entirely the appellant's choice. It decided and is continuing to contest the arrest there. So his repeated complaints about attendant costs and havoc are hollow, because if havoc is the right word, well, that was his own client's choice.
In the light of the judge's conclusion that the security offered on the 7th of September was reasonably satisfactory, if that were now to be tendered to you in the form of a signed letter from the Britannia, would your side give up the security in South Africa?
Well, subject to the respondent's notice, I would have to take instruction, but clearly we would be, and there might be some decisions to be made about costs in South Africa, so it's not a completely uncomplicated question, but in principle, yes, in principle.
I mean, the other side of that coin, of course, is whether Britannia would be prepared to offer that security, because otherwise, if they succeed in South Africa, then your valid claim is currently unsecured.
Well, I mean, this is one of the points about the argument that just an offer is enough, because and I'll come to I think I'm coming to the contractual analysis complaint, but then again, perhaps I'm not, so I'll deal with it now. one of my points in my skeleton was to say, well, if you have an offer and it's rejected, then the original offer no longer stands. And Mr. Thomas says, well, no, that's not right. This is a different exercise. But it's not really, because you're trying to agree the terms of a contract, and that's offer and acceptance, however you like to do it. And a counter-offer is always a rejection. And the difficulty with the argument that says, well, if I've made an, even if he's right, if I've made an offer and you've rejected it, well, of course, you're entitled as the offeree to come back and say, I've changed my mind, I want the original after all. Now, perhaps you are entitled to say that, but at that point, the offeror could perfectly say, well, I've changed my mind too, and I'm not going to offer it anymore. And what could you do then?
Well, Mr. Thomas can hardly say I've provided it, but on the other hand, I'm not going to give it to you.
No, but I'm, well, that's true, but if that argument fails and just the offer is enough, and that complies, he says that complies with his obligations under the clause. So you have an offer, it's rejected, the offeree then changes its mind and comes back and says, I'd like that after all. The offeror could then, now no longer under the threat of arrest, let's say no, I've changed my mind, I'm not going to give it. You're going to have to make an arrest, and then I'll pay attention to you again. But meanwhile, my client is in breach and apparently is causing damages. The idea that offer is enough to perform the obligation under Clause C, or enough to trigger a counter obligation to accept, is a deeply troubling one. I've now lost my...
We were moving on to implied terms.
I've definitely moved on to implied terms. I'm sorry if that wasn't clear. So paragraph 66 of my note of skeleton ignores, in my submission, the commercial reality that would inform the parties' thinking when they're agreeing Clause C. And the thinking would be that a party will only go in search of security if it's either being offered nothing or if what is on offer is not satisfactory. And the other limit of their thinking would be that the possibility of tendering reasonably satisfactory security would exist, and then off the back of that, resisting or setting aside the arrest on the basis that the claim is already secured. If that's the thinking, well then where is either the necessity or the yes, of course, to the officious bystander? Paragraph 67 of Mr. Thomas's skeleton is an argument for implying terms wherever it's reasonable, but obviously that's always necessary but never enough. And it's not necessary in this case because the offering party's position is already sufficiently secured by the commercial realities and the existing law that I have described to your lordships. And moreover, and this is an important point, implying the term sought, whatever it might be, would shift the balance of power under the contract unreasonably in favour of the party offering security. Because the term assumes, term for which he contends, assumes that both parties to the CJA would agree to a greater exposure to liability for wrongful arrest than that of the general law. That's the point I make at paragraph 24 of my skeleton. Now, a term of that sort could be used to put pressure in the reality, well shy of a judgment from the High Court of negotiation, put pressure on the other party to accept security that actually does have flaws and isn't reasonably satisfactory. And the imbalance would be particularly acute in my submission if the party to be secured to be in breach even before the securing party has performed its own obligation under the clause of actually providing the security. Now, turning to my learned friend's officious bystander point, paragraph 71, two broad points. The first is a pedantic one. I'll say that up front because that's what my Mr. Thomas will say in reply. It's the bystander who asks the question. He or she does not get to express an opinion about the plausibility of the outcome. It's the parties who get to answer the question. But that aside, the answer would be against the implication of the term, essentially for the reasons I've just given. Either it's unnecessary because the securing party can improve its position by providing or tendering security, or it's unnecessary because in the great majority of cases, reasonable security, when offered, would be accepted, or because in reality all that Clause C does is put a frame around the existing position and encourage negotiation, or because it's incompatible with the ASG 1-2 structure, or because of the power shift point that I've just made, or because this isn't a term that would be implied given the need to cater for timing and so on, which is my Respondent's notice point. I'll come back to that. And my lords, that also answers the point he makes at paragraph 72, page 111. The key word in that paragraph is generally. And even if it were appropriate to imply a term, real care would have to be taken over the term to be implied, which is usually antithetical to the implication. And secondly, most parties in this sort of situation would be very slow to agree to give up the right to arrest, particularly if there might be a dispute about the reasonableness of the security on offer or provided. I mean, this is it's almost turkeys voting for Christmas, saying to Admiralty lawyers, I want you to advise your client to give up the right of arrest as soon as you're offered or provided with reasonably satisfactory security.
But if you're offered reasonably satisfactory security, even if you got an arrest, you're going to lose it if you just suddenly turn around and say, I'm not interested.
Well,
I mean, you arrest the ship.
yes.
The counterparty comes to you and says, you've arrested my ship. Here is security.
Yep.
In a form which the court determines subsequently is reasonably satisfactory to you. You can't then maintain the arrest.
Well, no, at that point, no. But the key point in that example, my lord, is the court's determination.
Yeah.
And that, I'm afraid, takes time, even on an urgent basis. And the point is that you're asking litigators who spend their lives disputing these things to say, we're going to be able to tell so certainly that this is reasonably satisfactory security.
Or it provides the English court with the jurisdiction to determine whether the security that's being offered is a reasonably satisfactory form of security as opposed to some other court where the ship may have been arrested.
Yes, and that's fine. It's fine giving the court has the jurisdiction by virtue of every other clause in the CJA apart from Clause C, but Clause C reinforces it. The court has then, Clause C.
It's a lot more
Clause C probably bestows it, actually.
But it's a lot more than just putting a framework in place for a negotiation.
Well, my lord, with respect, your lordship is absolutely right. Because of Clause C, because of Clause C, not probably, the court then has jurisdiction to determine that question.
So your position really is that under the CJA, the court is empowered to decide whether offered security is or is not reasonably satisfactory.
Yeah.
Once the court has made that determination, then you might be in a position to say, all right, we were disputing it, but now we would accept it. Your objection is that you shouldn't be held to be in breach before the court has made that determination.
That's right, my lord. I would add, of course, you might be behaving completely unreasonably or maliciously or capriciously, in which case you are still going to be exposed to liability for wrongful arrest, where it's completely plain you're being not playing with a straight bat. I'm looking for an idiom which doesn't sound offensive. But what this involves is saying, this requires us to recommend to our clients to take on a wider and an easier liability for wrongful arrest than exists in the general law. If you agree to this and you're just negligent, and you negligently resist security, which the court then says is reasonably satisfactory, which is what's happened in this case, then you're liable for damages.
But it wouldn't even have to be negligent, would it? It just have to be wrong.
Indeed, just have to be wrong. Quite. Now that's quite a step for the ASG to be recommending to its members to recommend to their clients. We want to make it easier for you to get sued for wrongful arrest. That's the effect of my learned friend's term. So, my lords, two further points on implication. I haven't addressed specifically the Trollope and Coles point. And I accept, notwithstanding the elusive quality of the term for which my friend contends, he only contends for one term. This isn't a Trollope and Coles case. However, what it is a case where, among other points, the court cannot be confident that the omission was not deliberate. One is left, this is my second point, with the point made in the second paragraph of my skeleton. The parties who are, or at least are represented by and through the ASG and so on, very experienced in such matters, did not include a provision to the effect contended for by the appellant. And at putting it at its very lowest, you can have no confidence that that was not deliberate for all the reasons I have been submitting. And in those circumstances, with respect, you should leave their bargain undisturbed and not rewrite it for them. But also I should add, so far as ground 2 of the appeal is concerned, that I accept that if I lose on ground 1, then I lose on ground 2, so I don't need to press it. So that brings me to the respondent's notice, which I will try and canter through. Ground 1, my learned friend's already addressed, it arises in direct response to the appeal. As your lordships will have seen, it is that the judge, for his additional reasons for rejecting the implication, have added the need for time, the difficulty of negotiating without rejecting, and for the rejection of security for reasons unconnected with form. Now, briefly on that, your lordships have paragraph 19 of my skeleton, which I'm not going to turn up and read out because I'm short of time. My learned friend accepts that the need to consider time is a truism, paragraph 80 of his skeleton, but his term didn't allow for it, and now he says it does, and if that is now the term he's advancing, well then I can't take that any further. As for negotiating without rejecting, this is paragraph 20 of my skeleton, paragraphs 80 to 81 of his. As I've already submitted, the parties are precisely attempting to negotiate a contract, and the language of offer and acceptance is therefore appropriate, even if it is something the offeror is contractually obliged to provide. And even if he were right, it doesn't meet the point. and that's because it wrongly equates an entitlement to receive something with receiving it. And this is the point I was already making. If there were an attempt to negotiate wording that came to nothing, my learned friend may be right that the recipient would be, quote, entitled, unquote, under the clause to security in the form of the wording first offered. But that doesn't mean that security in that form would be provided. Or rather, it doesn't mean that security would stand as provided. And it also doesn't mean either that it was not a breach, on his case, to try and negotiate in the first place, or that that security would then be provided. As I submitted earlier, if the incentive to offer the security has been removed, for example, because there's no credible threat of arrest anymore, then the security provider might well not renew the offer or provide the security. And the party might be in breach, but so what, for all the reasons I was discussing before lunch. On the former of those 2 points, if the provider, so this is the offeror, suffers loss following the other party's failure to accept reasonable security, and the offeror's failure then to provide it, the offeree would still be in breach for not accepting, and all it would be left with is a causation or mitigation argument by way of defence. And that might well work, but you can see the unattractiveness of that. And this isn't fanciful, because something quite like it happened in relation to the HSBC guarantee. My client didn't accept it within the timescale offered, and then raised concerns regarding its terms. My learned friend said there was no request for an extension, but there was actually quite a sustained attempt to pursue that option, but it came to nothing because the offer wasn't renewed. But the appellant still claimed for breach because it wasn't accepted within the time limit it had set. Now, form. I've been promising to address you on this. This is paragraph 21 of my skeleton, answered in paragraph 83 of my learned friends. And my point essentially is that clause C requires only that security be provided that is reasonable in form. And my learned friend's answer is that the identity and characteristics of the offeror are plainly part and parcel of the form of the security. And it's a small point. But the trouble with that is it requires the words in a form, in clause C, to be read as if they say, that is. You effectively cross out form because you're just saying, well, reasonable security. And perhaps that is the right reading. But
well, I mean, I could say I'm providing you security in the form of a payment into court.
But
that's the form of the security I'm providing.
Well, exactly, my lord. Or I'm providing you with security.
So it's not just the words on the page, it's what are you doing
exactly
to provide the security.
Or I'm providing you with security in the form of a club LOU.
Yeah.
But
or a bank guarantee.
Or a bank guarantee. But is the identity of the bank or the club, in other words, the person liable on the security, if it's not a payment into court, is that part of the form?
Why not?
Well,
if you offer me security and I say, no, you're offering me a guarantee, you're offering security in the form of a pauper's guarantee. I'm not accepting that.
I've been talking to my accountant, my lord. Well, that's the question. I mean, that may be the right reading, but if it is, it undeniably involves at least dialing down the natural meaning of the words used. Because in the context of ship arrest, form, when applied to security, would naturally be understood to refer to the typical methods of providing it. So payment into court, LOUs, bail bonds, whatever. And probably the terms of it.
I mean, the amount.
And the amount.
I mean, is this really just almost a sort of form of syntax that what's reasonably sorry, what has to be reasonable is the security that's offered in all its respects. I mean, is that not really what that in a form means? It's not limited just to the type or the method of provision, is it?
My Lord, one of the best pieces of advice any of us has ever given is when in a hole, stop digging. And I'm just going to move on to my next point.
I think you have better points than this one.
I'm grateful for that indication. Grounds 2 and 3. Now, before I come to grounds 2 and 3, my learned friend makes the point in paragraphs 86 to 87 of his skeleton that I'm challenging findings of fact. And I accept the general force of the points he makes and the authorities that he cites. But of course, there are cases, and this is, or subject to one point, should be one, where the Court of Appeal does reconsider findings of fact, particularly secondary fact. The challenge to the finding of reasonably satisfactory, in this case, doesn't depend on disputed primary fact. To the contrary, it's closely bound up with matters of law and policy, and saw the judge taking into account matters he shouldn't have done and leaving out of account matters he should have considered. So if it is necessary to go that far, and I accept it may be, his conclusion on the points that I'm going to take.
Well, it's not a finding of fact in the classic sense of, was the car speeding, but it's an evaluative judgment taking into account a number of different things.
Indeed. And so I may have to say, well, it's a conclusion that no reasonable judge could have reached, and if I do, then I do. To take the points in turn, just on this findings of fact point, the difference between reasonable and best endeavours, which is one of the points, that's really one of law, and in any event, he declined to reach a conclusion on the point. So in theory, at least, there's no decision to attack. Secondly, the restricted scope of the secondary obligation is a matter of construction of the words used. So that's not a factual question as such at all. Respondents notice 3A is the form point, and I'm just going to skate over that. 3B is a question of the proper approach to the evaluation of evidence. The challenge is limited to his dismissal without proper consideration of points on the ground that they were not advanced at the time. That's an error of principle that contributed to an erroneous finding of fact. If he directed himself properly, he would have considered the reasonableness of the points in question on their own merit and not, or at least not solely, by reference to whether they had been raised at the time. Now, point 3C, and I'll just remind myself what 3C is. Yes, 3C1, this is the point about the secondary obligation and whether there was, in fact, any regime under which an application could have been made. I accept I cannot advance 3C1, which is the OFAC point. This is the point I was trying to make, that the judge said, well, yes, making an application for a permit might be a first step. And I made the point in my skeleton, but if we're dealing with a situation where there is in fact no sanction that's preventing the payment, it's just nervousness on the part of the bank, then how can you apply for a license permitting you to do something which you are not prohibited from doing, because that's not how OFAC seems to work. My learned friend has said, well, hang on a sec, there's no evidence of that, wasn't pleaded, and I accept that, so I'm not going to pursue it. But with the exception of that, the points raised are open to me and can and should be revisited by your lordships. Both of these grounds go to what I have called the secondary obligation under the clause, and by that I refer to the obligation on the club in the event that something sanctions related releases it from the primary obligation to pay.
It's really an exemption clause of sorts, isn't it?
Well, I don't think it is, my lord, with respect, and I'm not sure it's a helpful analogue.
No,
what it's saying is,
obligation. So you're not objecting to, yeah, right, secondary obligation.
So the primary obligation is pay
Mm-hmm.
in certain circumstances. But in the event that you can't pay, either legally or as a matter of practicality, because of something to do with sanctions, I paraphrase, then you're let off the primary obligation. But there is a secondary one. And it's the secondary one that I criticize, because in essence, what the secondary one should say in order to be reasonably satisfactory is if you run into problems because of something sanctions related, you must exercise best endeavors to pay, or well, you must exercise best endeavors to pay. Now, payment can be achieved in many ways, not least things like set-off between clubs and their members, and also between individual clubs. But there's nothing of that. Instead, you've got a very confined, very limited secondary obligation that simply says, if you can't pay, well, you must exercise reasonable endeavors, which is a bit wet, so we say it should be best, to obtain such permit as may be reasonably obtainable to enable you to pay. But that's very limited. And the judge made the point, well, as regards reasonable endeavors, well, this is an IG P&I Club, and therefore reasonable probably means best anyway. The difficulty with that approach is the Shanghai shipyard problem. In Shanghai shipyard, which is in the bundle, but shorter time, so I'll just explain the point. The question was it a demand bond or a see-to-it guarantee? Something I'm sure your lordships are familiar with, only too much so. And the conclusion reached by Mr. Justice Robin Knowles at first instance was, although this wording was very similar to wording that had been held to be a demand bond in another case, in that other case, the guarantor was a bank. And in this case, it wasn't a bank, it was a parent company. And therefore, although there was no practical distinction between the words that had been used, it should be not a demand bond because Paget's presumption as to demand bonds didn't completely apply because it wasn't a bank, it was a parent company guarantee. And one of the points made, and the references in my skeleton by the Court of Appeal, is no, you can't do this. You can't have the same set of words used by two different people and have them mean something different because of the identity of the parties. And that's the problem with the judge's approach to saying, well, because this is an IG P&I Club, therefore reasonable means best, or might be taken to be best, or all reasonable. No, it doesn't. Reasonable means reasonable. And he may be right that an IG P&I Club would do its best in practical terms. But the difficulty with that approach is that this isn't a comfort letter. It's supposed to be a hard-edged contractual undertaking which gives rise to rights that can be litigated. It's not a gentleman's agreement. And so if you have a secondary obligation which is as narrow and as weak as reasonable endeavors to do something not terribly consequential, then that weakness and narrowness means that the obligation as a whole, the LOU as a whole, is not reasonably satisfactory. Because if you do run into the problem of sanctions, you've really got nothing very much to fall back on except this one narrow, rather weak provision. And that, in a nutshell, is my submission on grounds 2 and 3 of the Respondent's notice. And so I'm not even going to check that I have covered all the points. There is then ground 4, which is the HSBC guarantee. I mean, it's in the Respondent's notice, but analytically it's probably part of the appeal because it arises if my learned friend wins on his appeal, but I win on the Respondent's notice. In other words, your lordships conclude, yes, there is a reciprocal obligation under or implied into clause C, but on the fact actually this wasn't reasonably satisfactory security for the reasons I've just advanced. And then Mr. Thomas would say, well then here's my trump card, which is the HSBC guarantee, which is offered at a considerably later point in time.
Well, let us suppose we get that far, for argument's sake. What do we do? Do we decide the point, or do we send it back?
Well, you could do
We're not usually a fact-finding tribunal.
No. You could send it back. If you went back, that might enable one of the points that's out there, which is whether or not HSBC would ever actually have put this up to, could enable some evidence on that, subject to Madden Marshall points and all that sort of thing. But that would be one option. But the points, I think it's fair to say, the points that are raised are relatively limited. So I'll canvass them anyway. And obviously we're in your lordship's hands as to what you do with them. If
So there is sufficient evidence, is there, on which we could decide that question, were we minded to? Or was it
yes,
necessary?
well, yes. I mean, the first point is, would HSBC have put up the guarantee? And on that, there is virtually no evidence. And my learned friend will say, that's because you didn't plead it. And that's a fair point, we didn't plead it. But we did point it out in a witness statement that was served well before the trial. The reference to that is page 89 of the court bundle at paragraph 59. As a result of the point being raised in my skeleton before trial, a couple of emails were produced, but they really go nowhere, and I don't think my learned friend really says they're getting home. His big point is, well, you wouldn't have had responsible solicitors making these offers if HSBC hadn't been serious, but we've simply no idea about the lines of communication.
Paragraph 59 raises the point very obliquely. This is a witness statement from your side saying, looking back, I also realised that we never saw anything from HSBC to confirm it was willing and in a position to provide a guarantee in any form. We could only take on trust that it was. I mean, it's not saying, it's not actually taking issue with it. Actually, we said we took on trust that HSBC would. So
that is what it's saying, my lord. And it may be that your lordships then have sympathy with my learned friend's point. It's all too late for me to make that point. But that is part of the.
That's the totality of the evidence, is it? Apart from the document itself.
There is the document itself, which doesn't have HSBC logos or anything on it. It's not an HSBC document as such. There are two emails from HSBC which are completely inconclusive. And I'll let my learned friend take them to you and persuade you otherwise, but they really are entirely inconclusive. That's it. And this is a party which is extremely capable of producing evidence when it wants to. It even produced evidence well after the close of evidence in the underlying collision action. It's not backwards at coming forwards when it finds material that helps it, however out of time it may appear to be. So, but then I'm giving evidence. So the bigger point which your lordships can more readily decide is that there are, I say, at least 3 terms of the guarantee which make it not reasonably satisfactory. And the competition here is between paragraph 53 of my skeleton and my learned friend's response in paragraph 114 of his. And so if I can just make, as it were, some additional or overarching points. The overarching point, I realise I'm not taking your lordship to the things. So the queries include a provision in the guarantee saying, if we're going to pay against a settlement agreement, the appellant has to send us a copy of the settlement agreement before we'll pay. And we'd say, well, no, that won't do, because then you can put a spanner in the works by not providing a copy of the settlement agreement. And my learned friend's response is, yes, but there are ways around that. You can make that a part of the settlement agreement so that there isn't a settlement unless and until you've sent it and all the rest of it. And he raises analogous arguments in answer to my other points, which are that in essence, the unfortunate wording of particular clauses gives rise to arguments which could stifle the effect of the security. And he says those arguments are really weak. But the overarching point is that the purpose of security is to secure. It should provide, to be reasonably satisfactory, an unarguable and straightforward route to payment. That's the point of it. You take it and you cash it in. And it's no answer to the points in my paragraph 53 to say that there would have been ways around the problem or that this or that argument would have foundered in court. It's perfectly reasonable to want those matters ironed out before the security is acceptable. And it follows, because these points were raised, that it was not reasonably satisfactory. He says that one of these points hadn't even occurred to my client by the time of trial. But that is completely wrong, because it is reflected in the amendments that were proposed in 2019. And one can see that at page 85 of the core bundle. So, page 85 is the marked up copy of the guarantee sent by my solicitors to my learned friend's solicitors with points marked up that they wanted changed. And you can see in the middle paragraph, lines have been put through, and in the case of a written agreement, a copy shall also be sent to us. So that's clearly there. The point that he says we hadn't thought of before, one can see that it appears in various places, but one can see it at the end of the third paragraph. This guarantee is valid for 5 years from the date, but is automatically renewable for an indefinite period on your written request before the expiry date until your claim is resolved. And it's the word resolved that I query in my skeleton and was queried in this document. Because you say, well, as soon as your claim is resolved, this guarantee comes to an end. Well, if it's resolved, that could mean just decided on by the court. That's the resolution of the dispute. Now, it's not a terribly attractive argument. One can't imagine any of your lordships giving it much time. But it's certainly arguable. We all know barristers at the commercial bar who would run an argument of that sort. And the very fact that it gives rise to a hopeless argument means it's not reasonably satisfactory. You don't want security which gives, I'm not going to name names, but gives opportunity for the more inventive of us to run points which just delay the provision of the money. So that's my point.
Is your objection that would actually, without those words, mean that in the very instant at which the guarantee would become live, in the sense that the judgment was given, that it would disappear in a puff of smoke because it would expire? I mean,
That's one of them. Another is in the beginning, the opening line of that paragraph.
I thought your argument was not that is what would happen, but that somebody might make a bad argument.
Exactly. So in the first line, my lord, which is perhaps a stronger one, this guarantee shall be valid until your claim is amicably settled. So my solicitors have added and paid. So we reach a settlement agreement. In ordinary language, you've settled the claim. End of guarantee. Before you can call on the guarantee. I mean, it's an obvious nonsense, but there are people out there who would argue.
Okay, so that is the point. I mean, even though these points do appear obvious nonsense, the concern is that, because there are people there that would argue that this means the form is unsatisfactory.
Exactly. But, well, you're...
Okay. No, I mean, I understand the point.
And I had a case years ago where somebody sent security, which was signed, but at the top of it, it said draft. And we said, well, no, that won't do. You've got to give us security which looks like it's security, because we may have to enforce this somewhere, and they may not all be nice chaps like you, because in that particular case, you're American, and Lord knows what we might end up before. And the LMA tribunal agreed. No, you've got to provide something that looks like security and doesn't give rise to those sorts of arguments. You're not being given an opportunity to win an argument. You're being given an opportunity to be paid just to go and cash it in and have done. So, my lord, I've tried your patience with these points. The ground 5, as my learned friend said this morning, is the quantum adjustment that will have to arise if my learned friend succeeds only on HSBC. And perhaps the way to leave that is that if that is the conclusion that you come to, then we have to put our heads together before the order is drawn up, rather than inviting all.
Yeah, I mean, I rather had the impression from Mr. Thomas that the figures are agreed as figures.
Well, that's what we're taking instructions on. I think it's probably an arithmetical issue and no more. Right. So I hope it wouldn't actually divide us, certainly not require court's intervention.
My lords, if I can assist brackets further, this bracket.
Thank you very much.
My lord.
Yes, Mrs. Thomas.
My lords, obviously I would invite you if the points I make are either ones you have well on board or not assisting to indicate, and obviously to indicate if there's particular issues you wish me to address. I was going to briefly reply on our appeal, then turn to the respondent's notice.
One thing I'd like you to address
Yes,
is whether the security from the Britannia in the terms offered on the 7th of September is still available. Because if the answer is no, then it seems to me that, and if you're still trying to get rid of the South African security, your objective is to leave what is now being determined to be a valid claim entirely unsecured, and that might possibly cast matters in a different light.
My lord. Well, my instruction is as we pleaded that they were required to accept it, and that has never been withdrawn.
That's not an answer to my lord's question with respect. They may have been required to accept it, but is it now re-offered, or still on offer?
My lord, I understand that is the position.
It is.
It is,
And that's on instructions from the club as well as from the client, is it?
In fairness, Mr. Herring, he would like to confirm that's the position with both before I give this court that confirmation, and I'm sure we can do it in short order after the hearing.
Yes, all right, well, thank you.
That's our understanding, my lord, so we just wish, obviously, to confirm.
No, you mustn't commit the club without being sure you've got this.
I
understand that.
My lord, thank you.
I think it's important that you do.
My lord, so be it. My lords, we heard a frankly learned dissertation from my learned friend on the arrest, consequences, the position worldwide. It's very interesting. I accept what he says as a matter of law wholeheartedly. I'm not sure I accept necessarily how he characterises the practicalities of it. But my lord, what in my submission it illustrates par excellence is exactly why the parties would wish to avoid getting in to any of those very difficult, tricky situations. The range of options, difficulties, possibilities, outcomes is only too evident from what my learned friend described to you, his submissions. And that in our submission only serves to reinforce why this agreement and its package it brings with it must have been intended to cover avoiding all of those outcomes, good, bad, indifferent, and uncertain. Uncertainty, of course, commercially is one of the least favourite outcomes for parties, and sometimes they'll accept something less favourable in a quest for certainty. But in my respectful submission, that description, my friend, only reinforces the point I made in my own submissions about what the proper scope of this agreement was and was intended to be. And my learned friend described that there were smooth running systems to deal with these, and that there were good techniques referred to which coped with them. And indeed, this agreement, the CJA and the associated form is precisely one of those techniques. My learned friend's, I think, submission would be that actually the ASG have failed to grapple with the problems that they're well aware of and which face them, and that their solution is not something that runs smoothly or indeed addresses the issues it is designed to address. So, that is an overarching submission in our favour, and in that context, my learned friend, I think, on a number of occasions, spoke about clause C being toothless, and I think that was his answer to a number of points that your lordships threw at him, and one of the bases in which he suggests actually it doesn't really matter. In my respect for the submission, that is something we don't accept. Clause C, particularly properly construed, is very far from toothless. It brings the dispute about the issue of security within the remit of the same court that is going to decide on the merits of the case and is going to effectively marshal and control that litigation. And that is a court, this country, which is used for good reason internationally, because people do trust the courts in this country. They do trust the level of experience and expertise, and they trust them to resolve disputes with a minimum of fuss, a minimum of cost, and a minimum of disruption.
Well, I think, if I may say so, I think Mr. Turner accepted that. And his point, I think, was, well, of course there's utility in bringing the question of adequacy of security within the jurisdiction of the Admiralty Court, but that doesn't mean that you're in breach before such time as you've tested it in front of the court, if there's a genuine dispute about the adequacy of the security.
Well, I respect for that's obscuring the point. Is that and one of the points you made later, well, the solicitors wouldn't recommend to their clients to give up the rights to arrest for something when they might get the answer wrong. The short answer to that is the parties agreed to come here because, as I said, there's experienced lawyers who will more often than not be able to agree a solution. If they can't agree a solution, then they can go to a court which is readily available and can make a quick decision. And we've all been involved in cases in this situation where the parties say we cannot agree on whether the words of this security are reasonable. We would like to dig out a judge tomorrow to decide that, because there's a vessel waiting in a port that's either under arrest or threat of arrest. Will you please help us? And usually the Admiralty Court, Commercial Court, is very happy to do so. So that submission that the parties cannot have intended for there to be an obligation to accept this because somehow they might get it wrong is with respect, I think, putting the cart before the horse. It's offering a solution. If we cannot agree on those terms, we've chosen a venue, a jurisdiction, where we can get a prompt response rather than having to go, for instance, to Egypt, where there's absolutely no chance of us getting a response in the next 20 years or so. So
what's the position then if you could have gone to the English court, the Admiralty Court or the Commercial Court? It probably doesn't matter very much because you'd end up with the same judge, but you didn't. I mean, on the 7th of September or October, whichever it was, when you offered the sanctions clause and they said no, one or other of you could have said, okay, let's go and get a judge to decide it. But you didn't, and in fact it was only decided some years later by Sir Nigel Teare.
Well, my lord, of course, that could have taken place. My lord, I suppose my answer to that is that the point at which we're looking at this is the time the contract was agreed. So what individual parties may or may not subsequently have done, how they might have reacted to a situation, whether it was wise or in hindsight might have been different.
The question is whether, in the light of the background that you could go to a court, a party is in breach by, or is only in breach when a court has determined the reasonableness. I think that's the question.
That respect can't be right. The test is an objective one, as the judge found, and either the security meets that threshold or it doesn't. And in my submission, you wouldn't require, practically speaking, you're either in breach or you're not. And the fact that that may not be determined until, like so many of the disputes that this court hears, the determination of whether there's a breach may come later, but that doesn't mean there wasn't a breach at the time of the relevant event.
Your point, I think, is, well, even assuming that the parties at the time of the contract knew perfectly well they could go to a judge within hours to determine a dispute, or days, if there isn't an obligation to accept it, there's not much point in going to the judge.
Absolutely.
To which I think Mr. Turner's reply is, well, there is point, because the judge will order the ship to be released.
Well, my lord, that I suppose isn't the position, and it just doesn't make sense if this is the clause which requires provision of security and there's no obligation to accept it. It must be, my learned friends, and this is why his position, in my respect for the submission, doesn't fit with the wider picture. He says, I've got no obligation to accept this, but I do accept you could go off to court and in effect get it enforced. It's thoroughly illogical. He says, on the one hand, you can go to court with this provision of this security and get an injunction or get an order. Yeah, I've actually got no obligation to accept this. And if that was right, then he should be able to go to court and say to the court, I've got no obligation to accept this. You shouldn't interfere. That's why my submission, the point I made about the Kalang and that line of authority is only supportive of our position. If reasonable security is being provided, there must be an obligation if we get it.
Well, is that right? I wonder. I mean, you've no obligation, for instance, to give a cross-undertaking in damages if you apply for an injunction. But the fact is, you won't get it unless you give one.
No, Lord.
No obligation.
Well,
So you've arrested a ship. The counterparty's offered security. You go to a judge who says that's reasonable. So the arresting party is left with a choice. You either take the security and give up the arrest, or you don't take it, but because it's been offered, the court releases the ship.
But that in my submission, when we look at the various ways we put it, obviously if our primary case is right, that providing the security is sufficient, that is complying with our obligations. By them refusing to acknowledge that and the consequences, that puts them in breach. So I don't think it affects that primary...
Well, it goes to the question of timing, really, doesn't it? Well, I think Mr. Turner's position, and he didn't quite put it like this, is that we are entitled to a court deciding whether this security is one we should accept or not. And until the court's decided that, we shouldn't be liable in damages.
But I must say, I think we would disagree with that. Any case where there's a dispute as to what a term means, both parties are at risk of getting wrong and they're having a consequential order against them. But my point is that, I think my little friend put it in various ways, but one of them was, this is why the parties cannot have agreed for there to be a binding obligation to accept, but that would apply to any contractual term. And my answer is that actually, in this country, if the parties are unable to agree, then they have the ability to very quickly resolve that. So it shouldn't be the disincentive, which my little friend, I think, suggested it would be. And he's saying, you can't interpret this agreement in the way Mr. Thomas says, because we're giving away something and we might be in breach. I think that's an odd argument, if I might say.
One respect in which Clause C appears to be toothless, at least to some extent, is that without an arrest or the threat of an arrest, you can't enforce it. You can't make the other party put up the security. And he says that's illustrated on the facts of this case, particularly with regard to the third vessel, whose name I've forgotten.
Sakazai Kala. Well, my lord, again, I don't accept that, and getting away from the facts of this case, I think, is quite important. I don't accept there would be no way of enforcing it. It's a contractual obligation, and in the same way that the party could go to the court and seek release of the vessel, his clients could have come to the court and said, we want to effectively get a mandatory injunction, specific performance, that they provide security in the following form. And of course, there are particular conditions required, but in principle, they could do that. So it's not a toothless clause by any stretch. And again, my lord, the point is that if we are in breach, were in breach and failed to provide it, they would be entitled to damages. and we discussed what those damages might be. But another example I give your lordship is again our Egyptian example. If actually the vessel, had been arrested, refused to put up security, and she stayed there for 20 years being effectively lost, then they'd be able to claim the value of the vessel. So there would be some force in that. So, my lords, I don't accept that it's a toothless tiger if that's how it's put, nor that should affect actually the construction of the CJA more broadly. That there is obviously, a bigger picture, but in my respectful submission, the points I made about why the wording, why do you have an obligation to provide reasonably satisfactory security? Why do the parties bother to define that if there's no obligation to accept it? Still, I think, unanswered. And also the simple fact that the parties are seeking to avoid all of these difficulties that we've seen explained at great length. So that those, in my respectful submission, simply don't fall away because of this possibility on the facts of going for an arrest and all the rest of it. And my lord, the point that you made, that the parties themselves have conferred on the English court the decision of what is reasonably satisfactory, again is I'd respectfully suggest inconsistent with the notion that the parties intended there to be a right to roam around the world and look to arrest and get security elsewhere. If you're saying to this court, you're the arbiter of what is reasonable security, that, with the other factors I've mentioned, surely makes it clear that the intention was for an offer of reasonable security to be made, if that's the way we look at it, and to be accepted. And that is part of the, as I said, the package deal, if you like, that comes with the CJA, brings everything to one jurisdiction to resolve in terms of law, the merits and the security positions. So it's saying, the parties are saying, bring it all to one jurisdiction that we trust, and that will be the place where all these matters are resolved without disturbing either party's commercial activities outside that. And it is reciprocal. And it's another, I think, answer to my learned friend's point about, oh, well, they wouldn't advise their client to give up a right to arrest somewhere else. That, of course, is reciprocal. So it cuts both ways. And, of course, with every deal, there may be some advantages, but some disadvantages, but there are many more advantages. So it's not a one-way street in our submission, and that's not a point that should detract your lordships from the conclusion we submit is otherwise relevant. Just on the question of chronology, my friend suggested, and it's not relevant to the issue of construction, but to be clear, there were discussions, there were drafts before the arrest took place, insofar as it's relevant to your lordship. That's evident from the email with our draft LOU. You'll see there's a reference to previous drafts, and your lordships will see from the chronology also on page 157, drafts were being prepared and so forth. So it's not fair to say that somehow the arrest was the only thing that triggered the provision of draft LOU. Discussions were underway. But ultimately, in my submission, that's not relevant to the points of principle which your lordships have to deal with. My lord, on the question of whether the term for which we contend is obscure, with respect, it's set out in the grounds of appeal, and I accept that in response to my learned friend's point about timing, we would add within a reasonable time, but the term for which we contend is absolutely straightforward. So I think that's a point of some desperation, obligation to accept the security that is reasonably satisfactory to the offeree within a reasonable time. That seems to be a straightforward implied term or construction point that certainly won't have escaped my learned friend. And on the question of tender, I think Lord Justice Mayles dealt with that in my respectful submission. When we look at that, what our club did at the time was make an unconditional offer to perform. Said, we will issue this LOU. And in my respectful submission, despite some wordplay, that is precisely what we see in this situation. we were tendering performance, as we discussed earlier, there was then either an anticipatory or enunciatory breach by the other side saying, no, we will not accept that, full stop. And that's why the conversations effectively came to an end. Now, my lords, I'm conscious of the time, so I was going to deal briefly with the respondent's notice. Now, my lords, my learned friend, I think, dealt with this admirably briefly, and I will attempt to do so as well. My lords, the objections in principle, I think my learned friend accepted, and I obviously therefore will not spend time on quoting your lordship to your lordship, but we do submit that when one looks at this respondent's notice, it is very much the island hopping which your lordship very memorably referred to in his judgment in the Farge case. And what we see in particular is my learned friend picking up on some very narrow points in our submission which simply ignore the wider picture which the judge considered. Now, make the point that the judge did hear live evidence from the experts which went to this issue of the reasonably satisfactory nature of the LOUs. He had the evidence of those witnesses, and he questioned them, we questioned them, and so forth. And he spent 2 days effectively with us for his sins, debating primarily that issue. And that, the findings he reached, my learned friend tried to unpick by reference to 2 or 3 limited points. But what he ignores, in my submission, is the wider evidence the judge looked at and did rely upon. And our submission is twofold. A, his approach of if you like, cherry picking is unprincipled and wrong in principle. Even if you were to accept that his points were well made, which they're not, when one looks at the wider evidence and considerations the judge took into account, there is absolutely no reason to interfere with his finding. There's nothing to compel you to use the language, I think, of your lordship's judgment to interfere with that part of his findings. And to make good that submission, my lord, we set out in our skeleton at paragraph 90. There's 3 good illustrations of what the respondents ignore in their attack on this part of the judge's judgment. It's worth having a look at those, my lord. Because the evidence there are all matters upon which the judge relied. First, you have the unchallenged finding that the wording of the LOU was approved by the Sanctions Committee of the International Group. That's a pretty powerful point in my submission, one the judge did rely upon. My learned friend originally sought to argue against it by saying that when the IG did that, they would not have been concerned with ensuring that the parties in receipt of the LOU were properly secured. When we got the evidence, both of the experts agreed that the Sanctions Committee of the IG would be concerned in ensuring the wording did provide proper security to the party to be considered. So you have the international group of P&I clubs effectively approving this wording, and in so doing, it was obviously of the view that it did provide proper security to the recipient. Now, if that isn't a strong factor in support of the judge's conclusion, it's hard in my respectful submission to imagine what would be. The second point we highlight, my lords, is that other clubs and hull underwriters provided and accepted LOUs in exactly the same terms, and that included the respondent's own club. So, my learned friend may be right that all the examples we give were maybe later than this particular example, but that doesn't detract from the fact that other clubs and insurers are using precisely the same words. Unless the standard club has some particular characteristic or feature which doesn't make it notionally the same as these other insurers, again, the fact that those other insurers were prepared to offer and accept this very wording is surely a strong, cogent evidence of the reasonably satisfactory nature of the wording in question. Your Lordships will I hope see, I don't know if time probably doesn't permit for me to take you to them, but you'll find a series of those letters of undertaking at page 137 onwards. And for your Lordship's note, the one offered by the Respondent's own club is at 141 to 144. Your Lordships will see at 143 the same sanctions clause is incorporated. So again, if one's looking at that objective test, clear and in our submission compelling evidence that the judge's conclusion was absolutely right. And then we also refer to what is effectively the agreed position of the experts that the P&I clubs and the IG would have been concerned very much about the integrity and enforceability of the club's LOUs and the fact that it's vital that they are seen to honour their promises. And this goes to a wider point about many of the criticisms made of the wording. Pedantic, I would submit they are. But the judge took into account the position of the clubs and the seriousness with which the clubs take their obligations. And that is it.
But the difficulty with that submission is that, accepting as of course I do, that it's serious reputational problem for a P&I club not to honour its obligations, that begs the question of what the obligations are. And that's really Mr. Turner's point on best endeavours versus reasonable endeavours. You don't change the obligation because of the identity of the person who is giving the promise. Of course the P&I club will honour its promise. What's the promise?
Well, my lord, I don't quibble with that. I think, in my respectful submission, that the way he's portrayed the judge's decision is perhaps unfair. I don't. The judge was not in my submission saying that reasonable endeavours becomes best endeavours. He was saying that from the point of view, and this is putting oneself in the position of the recipient. The recipient is looking at the person offering the guarantee, and he sees it's an international P&I club. So whether what that party is willing to offer is reasonably satisfactory, it's relevant in assessing that to understand the position from which the club will react to its own promise. And that's the point that I would submit the judge was making. He wasn't saying, well, best endeavours really should be rewritten as, reasonable endeavours should be written as best endeavours. He was making the point in my submission that from the point of view of that recipient, he would say, okay, best endeavours, the clubs will do everything they can. So effectively, for me as a practical matter, I can treat that as something close to best endeavours. And it was the practical point, in my respectful submission, the judge was making in judging whether the terms were reasonably satisfactory to the notional recipient.
Seems to me that on this particular island, Mr. Leisner is making two separate points. One is the point my lord refers to, that P&I clubs won't welsh on their agreements. And the other is that it is important to them that they give what is considered to be proper security, because that's what the system is built upon. And if their LOUs are not thought to give proper security, even though they will honour them for what they say, then the system will collapse.
My lord, and that's very much the case. I think I have a quote here, the evidence was, in fact, the mere perception that LOUs are unreliable is dangerous to the system. The evidence was as strong as that, so even the mere perception of there being, my lord, I'm not sure that's in my skeleton, but that reference is 147, Core Bundle 147, from Mr. Leisner's evidence. He says at paragraph 24, even the mere perception that LOUs are unreliable is dangerous to the system. That's the footnote on our page, on page 116 in our skeleton, footnote 14. So, my lords, very much the background against which the judge made his evaluation of the evidence he heard, and in my respectful submission, he was very much entitled to do so. And also, in terms of my learned friend's complaint that he took into account matters that he shouldn't, and so forth, I think the nub of my learned friend's complaint on that front is that the judge, in his grounds of appeal, he says put too much weight on, but I think he may now be saying shouldn't have at all, have looked at the contemporaneous reaction of the club, which of course raised none of these points. Now, in my respectful submission, that is not a fair criticism if in this scenario you're gauging what is reasonably satisfactory to, objectively, what is reasonably satisfactory to the recipient, P&I Club. It's relevant to look at the actual reaction of the Standard Club, unless the Standard Club contends for some reason, and it doesn't, that it was acting in an aberrant or unusual or negligent way. Its own reaction is a reasonable and, we would submit, reasonably cogent measure of whether the security provided was reasonably satisfactory, and if not, why not? And if they didn't raise particular issues at the time, it is, as the judge, in my respectful submission, did and was entitled to, it is an indication of whether those are really genuine complaints and matters which would render this reasonably unsatisfactory on the objective test that the judge applied. So we do submit that the judge wasn't wrong to take that into account. Whether your lordships feel he put a little bit too much weight on it or not, that, my respectful submission, is precisely the evaluation that the trial judge is there to carry out as per.
Well, I mean, you can put the point slightly differently, can't you? Because it's not just a question of the security being reasonably satisfactory. It's got to be reasonably satisfactory to the offeree.
Yes.
So the first question is, well, why did the offeree find the security unsatisfactory?
My lord, exactly.
And that depends on the actual reasons that were motivating the offeree to reject what was on offer. And as a matter of evaluation of the evidence, you might give more weight to those which were expressed at the time rather than those which are thought up later on in the context of litigation.
Sure.
And then you ask yourself, well, what were, if those were the reasons, were they good ones?
Sure. And the ones that were actually raised at the time, the judge didn't find to be well made. It was in effect this objection that we won't take any letter of undertaking with any formal sanction clause at all. It was essentially what they added up to, and he found that was not a reasoned or fair objection. So, my lord, yes, we do submit it is relevant in that context. My lords, the other objections we've addressed in our skeleton in response. I don't know if there's any particular points that my lords would like me to address on that front. We've been through them in some detail in our written document. I'm not sure that there is a great deal I can meaningfully add at this stage, unless your lordships wish me to address any particular points. I think my submissions were going to broadly follow what I've put in writing. So to that extent, I'm not sure I can meaningfully add anything to the debate at this stage. Well, the HSBC guarantee, I think there's only two things I need to say on that. First is that we would, subject to your lordship's views, if you get that far, ask you to deal with it. The sums at stake are relatively modest, and the thought of going back for another hearing, I think, fills us all with a degree of dread. In terms of the evidential point, we say, frankly, it's too late, wasn't pleaded, wasn't brought out, and therefore, if your lordship's prepared to make a decision, you should simply exclude that point. On the other points, I think Lord Justice Snowden has identified the nub of them there, that there's this suggestion that because somebody somewhere might be daft enough to take a bad point, the points of construction are sufficiently important to render the guarantee unsatisfactory. That speaks for itself, and we submit plainly isn't a good reason for refusing to accept that particular guarantee in that form. So well, those are very briefly what we'd say in relation to the HSBC guarantee. We obviously hope that we don't get that far in the equation. So my lords, unless there is anything else.
Thank you very much, Mr. Thomas.
Oh, sorry, bear with me. My lord, we're instructed, if you excuse me for just reading, that the offer of the LOU in the terms of the draft is open, subject only to the return of the UK Club LOU, which obviously was obtained in South Africa. So that's.
And the HSBC guarantee or not?
My lord, I'm told you can't get instructions at the moment on that.
Right. All right. Well, thank you both very much for your very interesting and, to me at any rate, very educational arguments. We will reserve our decision. You will get a draft in the usual way. The draft comes subject to an embargo, and it means what it says, as you will have noticed from recent decisions of this court. We hope that in the light of the draft, you will be able to correct our English, but not our reasoning, and that in the light of the draft, you will be able to agree a form of order disposing of the appeal, including, if need be, the figures. If you can't agree a form of order, please make short submissions in writing, and we will make the order that we think appropriate. Thank you very much.
Yes. Yeah, of course.